So this can be recorded and then be sent out as long as, and I don't think Brenda will mind. And we will go ahead and turn it over to her.
Okay. So apparently my family has come to visit, which explains why my dog decided to lose her doggy line. So, all right, let's try this again. All right. So again, we're going to talk about the Uniform Parentage Act, which is also known as the UPA, because, you know, things are hard and words take time. So we're going to go into it in the family style way, which I think is a lot more fun because it's easier to put people's faces and names. For those of you who haven't ever watched the family style cartoon, first of all, shame on you. You should try. It's on Fox. Here's our family style family. We have Meg from the left, Peter, who's a dad, Lois, who's a mom, Stewie, who's a cranky baby. And then we, of course, have a talking dog because every family has a talking dog. And then we have Chris. So that's our basic group of players in this little menagerie we're going to have today talking about UPA. In addition, on our list, you're going to see two other players, Quagmire, who is Peter's best friend, and Mayor West. So first of all, some of the boring stuff about UPA. UPA has a lot of provisions. It comes from a uniform law. We're trying to get states across the United States all on board, making paternity determinations the same way. But states have the right to accept all of UPA or parts of UPA or none of UPA. For us, we're going to look at section 102. That's a big section. Some of the sections that are highlighted are the names. And I bring up those names because if you look at PARB files and you look at juvenile files, what you see is NF, which is natural father. You'll see under the law that term doesn't exist in the UPA. We have 4 different types of fathers. We have acknowledged, adjudicated, alleged, and presumed. But nowhere in the law do we have a natural father, which is really funny because when I deal with my office, they get lost really quickly when I talk about natural fathers. Uniform Parentage Act is the law that we're required to follow whenever we make any kind of paternity determinations here in Oklahoma. So what does it do? It gives us the laws that help us decide parentage. And of course, parentage for our cases in juvenile court means maybe we can identify a dad and send a kid home and out of foster care. So it's important for us. How do we establish that relationship? Well, the first one is obviously the mom. Moms give birth or moms can adopt. The next way is a whole lot of ways that we can establish dads. And we're going to talk about those whole lot of ways. So the presumption of paternity is the very first thing in the law on how to determine it. So we're going to talk about it first. The very first presumption is marriage, and we're going to get there. But here's kind of what we're going to cover real quick. And I will say that I timed this, so it's going to start cycling through. But if you need me to, I can stop it and we can go through question and answers. Just let me know. The most common presumption of paternity, like I said, is marriage. So Peter and Lois got married, yay. Now we know if they have kids, those kids are going to be children of the marriage, and that presumption will apply. The next most common presumption is a dad who lives with a child and holds the child out to the public as his child for at least the first 2 years of the child's life. If and when that happens, a presumption of paternity can also apply. So here's the other presumptions of paternity. And I will sum them up by basically telling you there's 5. 4 of them, the very first 4, all deal with marriage. So in dealing with marriage, it has to deal with child born during the marriage. The second one is a child born within 300 days of the end of the marriage. That's very common that sometimes people will get divorced and 6 or 7 months later give birth to a child. The other 2 are basically mom and dad married. Marriage can be determined invalid and then invalidated. But a child born during that invalid marriage is still a child of the marriage. And then if mom and dad get married after the fact, but dad puts into basic writings that he is the father, that's the other way that we presume he's the father. So there's a lot of ways to get to that presumption, but let's talk about the Griffin's oldest child, Chris. Let's say that Lois and Peter got married in 2000, Chris was born in 2005. Who was Chris's dad? Peter. That's the easy one. Chris is definitely a child of the marriage. So let's talk about Meg. Unfortunately, Lois and Peter get divorced. Meg's born 7 months later after their divorce. Meg's not listed in their divorce decree. Lois says that Meg's bio dad is actually Quagmire. Lois and Meg lived with Quagmire for the first 4 years of Meg's life. So who is Meg's dad? So the first option could be Peter, because Lois and Peter gotten divorced, but this baby was born within 300 days. Or it could be Quagmire, because Quagmire lived with the child and held the child out as his own, right? So raise your hand if you think it's going to be Peter, or if you think it's going to be Quagmire. We'll see how many of you are right. So the presumed dad is going to be Peter. And Peter, of course, didn't have sex with her and is going to be surprised that that's what the ruling is. But why is that? Well, because we have these competing presumptions of law. And like I said, 4 out of those 5 presumptions of law all hinge on marriage. So when that marriage attaches first, it doesn't matter that 2 years later, somebody lived with and held the child out as their own. So can Quagmire establish his paternity on Meg? Well, yes, is a good answer. There is a timeline, and the basic timeline is 2 years. We can rebut that presumption of the marriage, but we have to do it under the law, and we have to do it with an admissible genetic test. And we'll talk about how we get to that in just a second. So the process for challenging this presumed father with a child under 2 years is so easy, it's not even funny. You can file a challenge anytime before the kid's birthday, or you can give these parents the forms that we call the acknowledgement of paternity, otherwise known as the AOP, and the denial of paternity. If we give the acknowledgement of paternity to the bio dad and the denial of paternity to the former husband, and they both complete the forms, and mom signs her form, then problem solved. We don't need to file a challenge. We now have an equivalency of an adjudication of parentage. So what happens when we got a kid like Meg, who's now 5 years old and well past that 2-year time limit? Then we run into these extra steps. You can still get the challenge, but you have to meet these extra steps. The first set of steps has to do with access. And by that, it's when I have to ask really, really intrusive questions into people's life and their sexual relationships. And then holding out. What the law says is if you cohabitated and had sexual relations during the possible time of conception, or this person held the child out as his own, then you don't get the right to challenge paternity. So if I go into this type of hearing in juvenile court, I usually start with an apology, because I'm going to ask somebody a very direct question, and it's not something that you ask people that you literally have never met in your lifetime. So I usually start with who I am and what I do, and then I have to ask them these questions. So for this, I would ask, when did Lois and Peter get divorced? And when was this child born? And that's going to tell me the presumption of law applies. And then I'm going to ask, did Lois and Peter have sexual relations at the possible time of conception? And I learned a long time ago that you can't be nice and polite and euphemistic. You can't ask, were you in a relationship or were you monogamous? You literally have to ask the question about sexual relations with this person. Once I find out they didn't have sexual relations, there was no access to each other, then I'm going to ask if Peter ever held this kid out as his own to the public. And pretty much probably no is going to be the answer. So then I'm going to have satisfied that we can get past this 2-year time limit, and the court can now move into the process of whether or not there's a challenge on paternity. So if this 2-year time limit does apply, then Peter's dead. That's the problem. If it doesn't apply, then the court can now hear a challenge, because all of that questioning and all the embarrassment I have to do, none of that is the actual challenge. All of that is just getting us to the fact that we can now have a challenge. So some of you have been out at juvenile court, and some of you have heard this wonderful term, and I love it. It's called the switcheroo. This is the one way around Peter being the presumed father. If I have the former husband, the former wife, and the alleged father all come in and they all want to testify that I'm not dad, he is dad, and I want to be out. And the other guy says, I am dad, he's not dad, I want to be in. Then the court can take this testimony and they can get to the point that they can allow a genetic test to be ordered. Presumably that genetic test is going to come back and say that Quagmire is Meg's dad. If that happens, we're going to be able to enter an order that says Peter's not Meg's dad and that Quagmire is Meg's dad. But in order to get there, you have to follow the steps. There has to be an actual motion to get this challenge going. People have to get served, and we have to actually end up with an order that somebody is dad at the end of the day. So Article 6 of the UPA has a whole lot of information, and I wasn't really sure the depth of who was going to be on this training, so I didn't want to go into stuff that was going to bore you to tears. So I'm going to tell you the basics. It has to be a civil case. Only certain people have the right to sue. Other certain people can be added into cases. The big thing in Section 6 is Section 637. And that is a law that says who is bound by a determination. For Lois and Peter, the divorce decree, they're both bound by it. Excuse me. For the child's attorney, not the same thing. And we'll get into those details. I'm so sorry. So the basic process for a child's challenge is the child's attorney files a challenge. The court hears that testimony to determine whether or not it has jurisdiction. The court then holds a best interest hearing. Best interest is basically determining, is it in the child's best interest to allow for a genetic test? Because the person that I test may or may not be confirmed as the dad. So if it's a relationship that the child already has, and I may disprove this person, is that really in the kid's best interest? If the kid's had a 3 or 4 year relationship and thinks this person is their father, and now you want a genetic test and it may prove it's not, then are we doing the kid a harm or are we doing the kid a service? And that's always something that the child's attorney has to decide. I know that I've asked the child's attorney once or twice to go ahead and file that, but ultimately it's the child's challenge to make, not child support's challenge. So once we get to a best interest hearing, then the court will decide whether or not that genetic test is in the best interest. And if they do, we're going to get a result. Hopefully the result is going to give us an answer as to who the actual parent is, and then we'll end up with an order that adjudicates parentage. So those are the questions that we talked about with the presumptions. How do they come about? What do you do when they compete? Who can challenge? What time frame can you challenge? What do you have to do to get to the hearing, to get to the genetic testing? And doing the switcheroo and the best interest hearing. So we have a whole lot of other ways to still establish paternity. Our first one is the AOP. We have parents who come to court and voluntarily admit. We have parents who get served and don't come to court and they get defaulted. We have parents who refuse to go take a genetic test and they get defaulted. And then we have on the right side of the slide, all the other opportunities, the divorce cases, the paternity cases. I've actually seen paternity established in guardianship cases because it can be. It can be established in juvenile court. And one that I did not put on the list because it does not happen often, but it can happen, is in probate court. And then of course, obviously you can establish parentage through an adoption. So we want to go into the AOPs. I know a lot of people hear about them in court. Some people call them the poor man's adoption, because if you sign the form and you don't take the form back, then after 60 days, that form is locked in. And even if you're not really the bio dad, if you're the person who signed it, you're the dad. So We're going to talk about all of this stuff, the rescission timeframes, things like the husband's denial, what makes a 209 or the acknowledgement form, what makes it void, what makes it voidable, what are the different problems that show up in juvenile court specifically with these forms, how do they get challenged, who can challenge them, and what are those timeframes. So, as I said, the person who claims to be the genetic father of the child is the person who gets to sign this form. They are signed in the hospital, and the hospital staff have outreach through child support that we go in and we train them on how to deal with parents and introduce these forms to them. The forms also have detailed instructions on the back page, and the parents are hopefully given copies of these at the hospital. It must be signed by both parents in order for it to be valid. If the child is born during a marriage on somebody else, then there's a specific time frame that it has to be signed. Now we're going to talk about the 209 on Stewie. Stewie is born June 1st, 2020 during COVID. Peter and Lois signed the 209 June 2nd, 2020. Stewie comes into state's custody because Lois and the baby test positive for drugs. The court orders that all of these Griffin children are now getting picked up. So it was a beautiful day in the neighborhood. All was good, except Stewie was already starting to come down and withdraw from drugs. So poor child, but hey, we got the baby pictures and then he got picked up. So we go into show cause on June 4th, 2020. Court liaison tells the court we don't have paternity established, and the parents go, but we signed a 209. Great. Now child support's going to start researching that 209. At the next court date, we go back. The parents get served, case gets filed, and they have a court date coming up on June 22nd, 2020. So the 209, we don't have any problems with it, seemingly. It's signed by both mom and dad. Lois was not married at the time of this birth. Nobody wants to challenge it. Nobody wants to take it back. We now have a copy of it as child support. So the probable resolution, we're going to enter a decree of paternity. This will take Peter from being an acknowledged father with a piece of paper that he signed to being an adjudicated father with a piece of paper that the court now signs. It also makes him liable for child support. So scenario one, how many times does this happen? Peter finds out he may not be the father of Stewie. Before and as she's taken into custody, Meg tells Peter she saw Lois having relations with other men about 9 months before Stewie was born. So it could be this first guy, it could be Quagmire, it could be former President Clinton. All of those are now options on the table. So now we're in scenario one. What are we going to do? In court on June 22nd, Peter, hearing what Meg said, is now not sure he's the dad and he wants a genetic test. So what can he do? Peter has 60 days from the day he signed this document to rescind this document, to take it back. So what we would do is we would print out a rescission form in court. We would have Peter sign off on this form. And then Peter or Lois or the DA or the child's attorney or even myself would have the right to then ask for a genetic test on Peter and Stewie to help find out who is the father of Stewie. So the rescission form can be signed by either parent, so long as it's done within 60 days of the first signature on the form. We can give that form out in court, and generally speaking, it can also be found at the OKDHS website.
And Brenda?
Yes, ma'am.
We did have a question. What
Okay.
is the effect of the father being on the birth certificate, but there is no 209 or AOP?
Unless the child was born of the marriage, there's no effect. Birth certificates do not establish paternity in the state of Oklahoma. Any other question on that? Nope.
Okay. Don't think
Okay.
so.
All right, so moving on to scenario two. So we'll say the parents go to court on June 22nd, they ask for another date. Now they come back. So ultimately we end up on August 14th. On August 14th, Lois is not really sure Peter's the dad. And now she wants a genetic test, but we're past our 60 days. So now nobody can rescind their form. So what do? That's when we start looking into the child's attorney having the right to request a genetic test and the right to challenge the 209. The child's attorney is not bound by a decision on paternity, basically, unless it is consistent with a genetic test. So scenario 3, this is where we really find out what Lois is doing. Lois and Quagmire were together until 2009 and they separate. Lois and Peter start living together in 2010. What Lois doesn't tell Peter is in 2009, she married Mayor West. And then later the same year, she left Mayor West. But she's never divorced Mayor West. So the 209 form has a small box, and it means so much to this form that it kills me when people lie or don't admit the truth. The form basically has a box that says, was mom married at the time of birth or conception? If so, it has an extra line to add the husband's name to the form. Basically, what that does is it triggers the person in the hospital talking to the mother to let the mother know, you should tell your husband they have to sign this husband's denial form. But usually what moms will do is they will just say, no, I'm not married. No, I wasn't married at birth or conception. So then we run into the issue later on where we do our due diligence, we find mom was married and we can't find a divorce, we ask in court, and that's when mom finally admits, well, yeah, I mean, I am married, but I didn't know I had to check that box. So that's scenario 3, but it does bring up our husband's denial of paternity. If the presumed or legal father husband is not the bio father, that person can sign the denial of paternity. That denial of paternity, in order to be effective, has to be done within the first 2 years of the child's life. If the denial of paternity is signed, in order to also be effective, it must have the acknowledgement of paternity from the person who claims to be the bio father. If you only ever get the denial of paternity and you never get the acknowledgement, the denial of paternity is void. So it will not disestablish a father unless you have both forms, because both are required by law. So we talked about if it's void, if she lies, or if it's voidable. So what's the difference? Well, it's void if it says somebody else other than the husband is the presumed father. It's voidable if it says there's another man, or it's void if it doesn't say. So it's voidable, basically, if mom denies that these people exist. So that's where we run into the form cannot be something that adjudicates parentage if it is void as a matter of law. Voidable.
Brenda. Oh, sorry. I want to jump in with another question. Barbara kind of led it, but it's something we see a lot. Once individuals are married, it's expensive to get divorced.
Yep.
And you will see, and I have seen parents who have multiple children, unfortunately, within the juvenile court system. And, you know, we're 2 or 3 kids in, and we keep every single child have to pull the legal or presumed or married the husband back to court because they've never been able to finalize a divorce. Is there anything that can be done besides divorce to stop that presumption of marriage from attaching for future children?
No.
What about a legal separation?
If the parents are still married, the way the statute reads, it's a presumption of law.
Okay.
So it's, I mean, annulment or divorce, I think, is the only grounds that's going to get around that.
Okay.
But we do have those frequent flyer parents. And what we tend to have run into in our court system is now we know where the husband is. The husband knows he's still married. we will get the husband's genetic sample, and on usually the first kid that we can find them on. So then subsequent children that come into custody with the same birth mother, I'll raise the issue that we have this presumed father, but we already have a sample. And since it was a sample collected in juvenile court, we have the ability to release that without asking the parent. So once we get service or even publication on the presumed father, I'll ask to test that previous sample. And then we can usually get rid of that person because we know they're not the father. And then we'll have a genetic test result that will show they're not the father. But yeah, I wish the state law would write something like once you're separated for 4 years or something, or pick a time frame, that would be amazing. Trying to remember where I was. Okay. So we went through the voidable, right? Okay. And next. So things are voidable when Lois admits she lies on the 209 and she says she's married at birth. So how are we going to fix this? Well, if we're still got a child under 2, which Stewie is, maybe we can hunt down Mayor West and get him to sign the husband's denial of paternity. If not, we can do the 607B questions. Those really kind of intrusive questions. Who were you sleeping with and who were you living with? And if not, we always have the child's attorney's ability to challenge that presumption of paternity. So if she's married, but we never get the denial, then the acknowledgement of paternity is void. It can't kick in because you have to have both documents. So you can still try and get Mayor West to sign the husband's denial of paternity, or kind of what I was saying before, have that court-ordered genetic testing to get rid of the husband. So if you do have an acknowledgement and the 60 days passes, the 2 people who sign it still have the right to challenge it. They have to show fraud, duress, or material mistake of fact. And I believe there's case law that says, well, she told me I was dad, and then 2 weeks after I signed that form, she said I wasn't. That doesn't qualify as fraud because lying is not equal to fraud, which is kind of crazy, but that's what case law says. But they have 2 years after these forms are signed in order to file their challenge. So the other people in the world, because let's get real, Stewie doesn't look like, you know, Lois or Peter really, but he does look like this guy. There's other people who can file challenges against the 209s, and it's not just the child's attorney, but there are timeframes that they are also bound by. So any person who's not the signatory to the AOP has to commence a proceeding within 2 years of the AOP being signed or the adjudication of parentage. So it's kind of a weird little opening time frame, but it gives another person. So I don't know this guy's name. Technically, I think it was a time travel episode and it's Stewie as an adult, but I thought he looked great like Stewie's dad. So, but this guy could potentially come in and still file a challenge and argue that he's the person, not the 209 dad. So the child's attorney to the challenge. Child's attorney has so much more leeway to challenge these things. Oops, it switched over really fast. I didn't want it to switch that fast. Hold on, we're going backwards. Okay, so child's attorney, basically to sum this one up real quick, is they're not bound unless it's by a genetic test. So they're not bound by the acknowledgement of paternity unless it's consistent with a genetic test. They're not bound by an adjudication of paternity unless it's consistent with a genetic test. Or they are bound if they previously represented the child. So if for some reason this child had a paternity issue, say in the domestic court system being resolved, and they did everything but do the genetic test, then the child's attorney would then be bound by that decision. So we talked a whole lot about AOPs. And then now for questions on genetic testing, because we get that all the time. In order to be used, it has to be admissible by court order, which means we have to have service and they have to be a party to the case. A lot of times what we get is child welfare will get a name from the mom, and then they start behind the scenes trying to get a genetic test, but this person's not listed on the petition and never been served. So until we get both of those steps, that person is not a party, and any test that got done would not be admissible in court. We do have GT that's enforceable by contempt. By GT, of course, I mean genetic testing. And by contempt, I love it. We don't use it, but it exists. If somebody absolutely refuses to submit a sample, technically they can be incarcerated. And the purge to get out of jail is to submit to the genetic sample. So I've never seen it used in juvenile court. I've never actually attempted to use it in juvenile court. And I will say that the law specifically allows for a default against a father who refuses to submit a genetic test. And that's why I've never asked to have somebody sent to jail for this. But it does exist. There's a probability of paternity that's required by law. It has to be met. So I love this little scene about the genetic testing and how we get there. The only thing that is a major rule is you cannot order a genetic test on a child who has not been born. So if the child is still in utero, it's not admissible. It won't be allowed. So we do have testing requirements. The testing requirements are really detailed and they don't really apply to anybody except me, just to make sure that we actually met them. So long as we're using LabCorp, we're always going to meet these requirements. But the basics are we have to have an accredited facility. They have to use the proper database because different samples get tested against different databases. If we ask a person to self-identify as Caucasian, Native American, whatever they self-identify is the database that they're going to be tested against. So it's very important that we do that. We have to have a proper chain of custody, which is sample when it's collected, how it's packaged, when it's shipped. Everything at the lab has to then follow that chain of custody. There have to be photographs, there are thumbprints. We do everything to prove that this is the person who got tested the day that we take that sample. When we do this testing, what I have learned is the testing we do is very, very detailed and meets all of our requirements. Unfortunately, what we have seen in juvenile court is we've seen those very young mothers that are very young teenagers. And because of the person that they were having relations with, those older adult men have faced either statutory rape or rape charges. And they have gone through genetic sampling in their rape cases to prove that they are now the biological fathers of children, which proves, unfortunately, the criminal act. What we've learned is we can't use those results in juvenile court because they do not meet the requirements under the UPA. We've tried to confirm all the chain of custody and everything else, and the testing done in the criminal court system is woefully inadequate compared to what we do in our civil court system. So inadmissible test. In case you didn't know, you can walk in pretty much any drugstore or Walmart and you can buy these DNA paternity tests off the shelf. People do it all the time. And all the time we hear people say, oh, we took our own test and it says I'm the dad. And I have to look at them and say, that's great, but it's not admissible. And obviously they're not admissible because number one, they're not pursuant to a court order. But number two, we also are lacking all of the chain of command. We're lacking all of the ability to confirm who even took the test. We don't have any documentation. If somebody walks in and says, here's my home test, I just look at them and say, that's nice, because legally it has literally zero applicability to our court case. So who can be tested? Well, pretty much anybody. Any of the alleged fathers can be tested. If we can't find the alleged fathers, the statute actually allows us to test the alleged father's parents. It allows us to test his other children. It allows us to test their mothers if we need to in order to establish paternity. So then we have the issue of identical brothers. The court can order genetic testing on identical brothers. Very, very often that will come back as 99% on both brothers. If and when that happens, then we usually rely on what we call non-genetic evidence, which is basically we ask the mother, which one of the brothers were you sleeping with, just to make sure. So those were the things that we talked about with regards to genetic testing. I don't know that there were any questions, but Kim, if there were, let me know.
The questions that we, the last question was, are samples still being taken at the Juvenile Bureau?
Yes is the answer. And it depends is also the answer. When COVID hit, LabCorp went to self-collection itself as a business. So different child support offices across the state then set up self-collection places. Basically, we would talk the person through how to get their own sample and have them glove up and do their own cheek swabs. The court liaison's office is myself and two of my team and the court liaison's office were all trained through LabCorp requirements in order to take these samples at the juvenile courthouse. When COVID hit, my understanding was the court liaison's office said we're not doing it, obviously for obvious reasons. I do not have that restriction through my office, so I have done it. I've collected several people. It's very difficult, next to impossible, to get LabCorp into David L. Moss. So we have had several instances where we've had to bring the parent over from David L. Moss in order to even collect their sample. So the answer is technically yes, but I don't know that all court liaisons are comfortable with it yet. And I don't think Lynette is requiring anyone to do it if they're not comfortable with it.
And of course, if there's anybody on that's joining from, because this invitation was extended to PARB members across the state as well, that's going to, most of our rural counties don't have child support representatives in them. So again, that procedure is very specific to Tulsa County. I'll tell you, in Oklahoma County, where I have a caseload as well, there is one child support attorney there. They do finally have somewhat of a fuller staff, but they don't attend every court hearing even. They try to attend on cases in which there are issues, but a lot of times, unfortunately, with paternity, you don't realize these things are going to be issues, and then all of a sudden they're issues. And I could give you examples upon examples. I mean, we'll be a year or two into a case, and all of a sudden it's discovered mom is married. And so whenever I started this, I'll be honest, I still find, even after 20 years almost, I still find myself, I refer back to the UPA in my cheat sheets constantly, because whoever knew it would be so complicated to do this. But I will tell you that doing it incorrectly can cause a lot of issues, down the road. So it's important, if you're seeing these issues raised in your cases, you don't have to always understand the UPA to point out that there might be a paternity issue so the court can address it, particularly in PARB recommendations. If you're reading reports where it states mom is married, and then there's a biological father, and every county has their terms. One of the terms that doesn't really appear in the UPA, but it's used, I think, most commonly, is legal father. So I was going to ask Brenda if you could give a better definition or equivalent legal father to these terms so that there's a better understanding of what that means.
Yeah, I can do that. What I think people are saying when they say legal father is this presumed husband father. Most likely. Generally speaking, if I'm hearing it in our court system in Tulsa, It's that mom says Quagmire is dad. Mom's still married to Peter, so legal father would be Peter.
And natural father is often used for bio father, biological father. Those terms I think are pretty interchangeable. Start hearing these issues. And that simply means the individual, I think a lot of times they believe to be that individual. That can also fall under the umbrella under alleged father as well. Wouldn't you agree?
Yes, very much so.
And then I think the only term that maybe for a lot of individuals you don't see ever written in juvenile court petitions is adjudicated fathers. You covered that briefly, but can you even summarize maybe again what would qualify as an adjudicated father?
Yeah, I can, and I'll touch on it again at the end.
Oh,
an adjudicated father is the person who's already legally been determined to be the father. Adjudication is just that fancy word for the legal determination's already been made. So in this instance, let's say Peter and Lois got divorced. Chris is in the divorce decree. Peter is, number one, he was presumed father, but he's also the adjudicated father because now he has a court order that says he's the father of Chris and orders him to pay child support. So those adjudications in what PARB would be reviewing would be something like the paternity decree, where it would recite on page 2 how we determined this person to be the father, or even the orders of non-paternity when we disestablish a father, such as the presumed father. There's orders that we use in Tulsa County that page 2 would explain that the marital presumption is rebutted, or the acknowledgement of paternity was rebutted, and it would explain how this person is now not the father. But both of those are considered adjudications. So that's what we would call an adjudicated father. Do you want me to finish up real quick?
Yeah, absolutely.
Okay.
Sorry.
All right.
Oh, we did have a question real quick, Brenda.
Okay.
And you may cover it through, but why do courts not use the same process for criminal and civil paternity cases to save money? And I'm not sure maybe what Kathy asked that question, what you mean too for criminal paternity cases.
I have to say, I don't know why they don't. I don't know that within the criminal realm, the aspect of proving it is not proving paternity for the adjudication of paternity itself. It's actually in the criminal realm as an aspect of the prosecution. That if this person has claimed I never slept with this woman, but this person tests out as being the biological father of that woman's child, then we know we can prove that this person had sexual relations with that woman. Otherwise, she wouldn't, I mean, unless there was a star in the sky, she wouldn't have gotten pregnant and given birth. So I don't know. I've never worked in the DA's office, and I don't want to do criminal law. So I don't know. I just know that under the UPA, our requirements for genetic testing are one very, very long statute about everything, accreditation, what it has to go through, and then even the databases, what your results have to be. You have to have a minimum result of 100 to 1. So anytime you don't have a result, if you have a result lower than that, it's actually shocking. GT results are typically in the, if not millions, in the billions to 1, like 17 billion people to 1. And that's shocking because I don't know how they have 17 billion samples to test against, but it's very easy to test. So, but these are some of the other ways on the screen on adjudication that we're kind of talking about the way to be adjudicated. So you can be adjudicated because you admit paternity and we do an order. You can be admit because you don't show up or you refuse to take a test and we do an order. You can get divorced and we do an order, or a paternity case and you get an order, and adoption case and you get a final decree of adoption. So all of those things and all of the adjudicated dad that entire thing all goes to dads who have orders. There are ways to challenge the adjudications. It just doesn't happen a whole lot. So these are the ones we've talked about already. The admission of paternity can be under oath, on the record. It can be under oath off the record. It can be in a written writing under penalty of perjury. If the court finds that it satisfies the law and it doesn't have any reason to question it, then we'll end up filing a paternity decree at the end. Default paternity decrees are, like I said, you get served and you don't show up. If you don't show up and you don't have a great reason, well, it doesn't matter. If you don't show up, you get defaulted. If you do show up, but you don't go get tested, you get defaulted. So when we do paternity decrees, we have specific requirements that we have to meet. We have to identify the child by their full name, by their date of birth, by their state of birth. We can change a name, the surname only, according to state law, if both parents agree. In our paternity decrees, we have to tell vital records to amend paternity decree or to amend birth certificates. And we do have certain language that we use, at least in Tulsa County, that will also tell vital records if you have another man listed on the birth certificate and we've determined our order, then you have to take the other man off and you have to add our person on. So our orders are pretty important. There is a challenge to an adjudicated father. It can happen. It has to be under the laws. If it is the parent themselves trying to get out from underneath the order, this portion of section 637 of the statute applies. It has to be done through the law, either by an appeal or by a motion or a petition to vacate. So far, I'm not sure what other judicial review, what those words actually mean, because I've never seen any other type of judicial review happen. So that's what we talked about on adjudications. Were there any kind of questions on that, Kim?
I didn't see any questions. I think one thing to round back to clarify was that when we talk about default findings of paternity, first, I think it's important to understand that the petition has to plead paternity as a ground. And in some counties, across the state, the DA's office does not always do that. They do not always plead paternity in a deprived case as a finding to be made by the court. And so, if you are looking at deprived petitions and wondering, that's a good place to start. Does the state's petition ask in its prayer for relief that paternity be established? Because if it doesn't, then even if we serve parents, we can't make that determination. Also want to clarify that unless there have been some recent changes to the UPA and particularly also child support, how that's computated, so I don't want to misspeak, but I don't think this has changed, but we in juvenile courts often, unfortunately, are not able to locate clients and we will have to serve them by publication. And if we do that, you are not able to use that service by publication to find paternity. Is that still?
That is my legal opinion. However, if it is a presumed father of the marriage and they are served, then you are not establishing paternity based on default. You are establishing paternity based on the presumption. And I do believe that paternity can be established that way.
And I should have clarified, I'm sorry, without a presumption.
Just an alleged random father, and it's only a publication notice. 13 years ago when I started this job, I had long discussions with my then managing attorney that I didn't feel we were giving adequate notice with publication to legally establish a relationship to that extent. And I was not going to be asking the court to default anyone based on publication. And since then, I'm pretty sure I have all the judges believing that. It's not statute. There is a statute that requires personal jurisdiction And I don't believe that publication rises to the level of personal jurisdiction under the UPA in order for myself to feel comfortable asking for the fault finding of paternity.
And that's how I've seen it interpreted as well in most of the counties that I've been in. So something to note, whether you're a PARB member, whether you're a CASA volunteer, when you're looking, at these terms, I think, again, paternity is like a puzzle. It's having to have all the pieces and the time frames, and no two issues are the same. But I think Brenda's presentation is a great guide. It helps familiarize you with those terms, with what you're looking for. The big points is that, birth certificates don't establish paternity. If you do just have a series of alleged fathers and you're a PARB member, I don't think it hurts at all if you're not seeing the courts follow up with paternity issues with those alleged fathers, to recommend that the court circle back to those paternity issues and be sure to address them, because the child could potentially lose out on a number of things when paternity is not established. It could result not, if ICWA could be involved, whether or not they're entitled to any type of disability benefits or income, inheritance, access to extended family and knowing their medical history and background. So when we tend to leave, and I would have to say in your bigger counties, I don't think that happens very often, but I've seen quite a bit and work with attorneys that work in rural counties where it just kind of floats. They bring the kids into custody, they deal with mom, and that's it. So it doesn't hurt to keep your eyes on the paternity issues if you're reviewing them. So, okay, go ahead, Brenda.
Okay. So there's random, but it does happen where you have a child with no presumed acknowledged or adjudicated father. There is no limitation to bringing a proceeding to establish parentage. The child can even do it after they become an adult, but the child has to do it if they do that. So where do you find paternity determinations? And this one I added specifically for PARB people going through these case files. If you are in a county where you have someone like myself, and I will say that Kim's right, not every county has a child support representative that goes into their juvenile court system. However, there are more deprived courts in Oklahoma than a lot of people realize that we are involved in, even if it's people that are tangentially involved and they're doing orders at their office, but they're getting them filed in deprived court cases. So in the deprived files, the easiest way to see if paternity has been established is to look for the order of paternity. So look for the paternity decree. If you're really nosy and you want to know how it got done, you can always turn, usually page 2 or 3 of the order will say specifically how it got done, by a genetic test, by a presumption of law, by an oral admission, by a default. It'll have those kinds of answers. The other form, obviously, is the order of non-paternity. It will tell you the people that have potentially been tested and have been excluded. Generally speaking, the only orders of non-paternity that we do in Tulsa County are because we tested that person and excluded them, or because we tested another person and confirmed the other person. So generally speaking, non-paternity definitively says this person cannot be biologically the father of the child. The other ways to look for child support, especially some of the smaller counties that are just getting these orders, the general child support order that we use in almost all juvenile courts across the state, paragraph 2 or paragraph 3 of that order will be a finding of paternity. So when we enter orders on the mom, we just put not applicable on that paragraph. But when we enter orders on a dad the first time, we're usually using that paragraph to explain how we established them as the father, because we can't order them to pay child support if we can't find they're the father. So, and then the last thing that you can look for are these dads who are the adjudicated dads who already had an order before they ever came into the juvenile court system. If that happens, you might find a modification order in your actual file instead of any of these other orders. And that's because all these other orders have been done on some other case, some other time. But a modification order, again, should point out the fact that we can't order child support unless we have proven this person is the parent. So that's my basics.
Okay. Thank you. And if anybody has any questions, feel free to take these next few minutes and ask or drop them in the chat. Oh, there we go. Pops up over there. But yeah, I know that seems really overwhelming, going through a presentation like that, but I think it's a good start when, like I said, PARB members, CASA, whoever it is, attorneys, when you're starting to get involved in these juvenile cases, to have at least some ideas of the vernacular, what they mean, how they might relate. And then, you can always ask questions of your child support representatives. Your attorneys that are practicing this should have a fairly decent idea, although I am constantly looking in Oklahoma County, it's GG. I'm constantly looking at GG and being like, I did just say that right, correct? But anyways, I hope that gave you all some background. I don't see. Oh yeah, shoot, go for it.
Yes. So I thought I was getting ready to withdraw from a case and not have to think about this anymore. And now, Brenda, you've given me so much to think about, because I think that I've missed something super, super obvious. So I was retained to help mom with a paternity action defending against, father trying to take the kid. And then we counterclaimed for dissolution of a common law marriage. And then dad's counsel showed me a marriage certificate and is claiming that mom is still married and never divorced somebody that she married in Spain. And and mom, how I will never be able to explain to you, has no idea if she's still married to him or not. And I was like, you can't be married to more than one person at one time. And so now we have the situation where we've had to back off the common law claim, but he's still making a paternity claim, but is claiming that she's married to somebody else. Where do I start?
If he's claiming that she's married to somebody else, then that marriage would seemingly have attached first. So that would be the presumed father. It would depend on the age of the child that you're now dealing with, a 5-year-old. You would basically need to go through those 607B questions about, has she been with the husband? Did she cohabitate? Did she have sex relations? Did the husband ever hold the child out as his own? And then once you get to that, then you'd be able to get into the actual challenge and figure out whether or not the genetic testing is best for this kid. But basically, you're going to need to put that husband in the rearview mirror legally if she cannot come up with a divorce decree from Spain or some other country that had jurisdiction.
Okay.
Because otherwise, I mean, he can't be the father. And if you're not the father, you're not entitled to custody.
Our jobs are really hard.
It's constant. So I'm going to take, if it's okay, Brenda, your slides and I'll send them to Keith to disseminate to. Jalen, you want me to send them to you? Is that best? Okay, to get to CASA, and then Jessica, I can get you yours, and I'll send to you, Barbara. So anyways, I think that wraps up our time and presentation. So I just want to thank Brenda again for doing this. And Brenda, if you'll just hang on for me before we all end. So I just have a quick question to ask you. But other than that, thank you. And thank you all for joining us tonight. And have a great evening.
You too. Thanks, everybody.
Thank you.
Thank you. Thank you.